Hi, everyone. Welcome to our presentation. Judge Reiser is going to start with an introduction.
First, I'd like to introduce the person who I consider California's leading expert on probate sales, Orit Gadish. And she has brought me into this, we'll call this adventure with the Judicial Council in an attempt to expand and refine the California rules of court associated with probate sales. You know, I can only approach it from a jurisprudential perspective, but Orit has been in the trenches now for quite some time. So for everyone's enlightenment, Orit is Hebrew for light, and Gadish means growth. And I think those the combination of those names is appropriate because in my experience, she's all about spreading positive light and creating partnerships which culminate, in growth for those folks who are involved. Orit has been the broker and owner of a boutique real estate brokerage, Geffen Real Estate, for almost 20 years. She exclusively handles the sales of fiduciary real estate, both commercial, residential. She actually began her career 2 decades ago at a commercial real estate brokerage. For those of you who are familiar with that, those folks, it was NAI Capital. In my experience for Orit, it's all about facilitating easy transactions, minimizing risks, maximizing returns for both the fiduciaries and their clients. So she has actually developed a proprietary platform, which consists of procedures, strategies, custom technology. I believe that when she sets her mind to something, she puts all of her energy and passion into it. I know in this project, she's been a ball of fire. Orit did launch her first book in 2021. I've read it. It's called The Practitioner's Handbook for Probate Real Estate. It is very highly regarded. I've passed it along for others to read. It does have, 5-star reviews, if that's such a thing. That's important to people. She gets things done, in my experience, quickly and efficiently. She was asked to revise the CEB sales of estate property chapter, and she did so. And we all respect CEB. They allowed me in the last few months to provide, I'll say, color commentary on petitions for final distribution and probate. Orit continues to be the annual update author on that chapter, and her 4th book is entitled Introduction to Real Estate for Fiduciaries. She did previous to that, because her experience is very substantial. She had executive positions in financial services, software consulting, but probably the most significant thing that I know about Orit is that she is a graduate of, I would say, the most august university in the UC system, UC Santa Barbara. She did tell me that instead of spending time on the beach, she worked with the Santa Barbara Police Department as a cadet and the community relations coordinator. I will tell you that when I was a student at UC Santa Barbara, I was spending time on the beach. So that's Orit Gadish.
Thank you, Judge. The job at the police department was and still remains my favorite, other than real estate, of course. I was always attracted to the law. I actually wanted to be a police detective, but life has its twists and turns. And now I'm here with you, Judge, to discuss how to change the law to make things better for others. And now I'd like to share with you all some interesting things about Judge Glen Reiser. I'm very grateful to Judge Reiser for partnering with me on this journey to improve the probate court's real estate process and procedures for court-confirmed sales throughout California. As Judge Reiser mentioned, we've spent many hours brainstorming and discussing ideas. Judge Reiser has provided me with his unique judicial perspective that stems from more than 20 years on the bench in Ventura County, most of which time was spent supervising and ruling upon all of the thousands of trust, probate, and conservatorship cases in that venue. Judge Reiser, as an attorney, Superior Court judge, and neutral, is responsible for many of the high-profile cases lawyers cite every day in the probate world, and most recently mediated and shepherded the litigated controversial resolution affirmed in Breslin versus Breslin in 2021 that I'm sure all of you are familiar with. For more than a decade through the end of last year, Judge Reiser works several weeks a year as a judicial trainer for all judges in California assigned to the probate bench, from orientation to advanced courses, including California probate real estate sales. So he's the perfect partner. Before becoming a judge, Judge Reiser spent more than 20 years as a trial and appellate lawyer in the areas of land use and real estate. What do judges do when they retire? You may wonder. Different things. As for Judge Reiser, I don't think he can handle the concept of retirement. Judge Reiser currently serves as a mediator with JAMS, as you all probably know already, using his unique talents to help resolve difficult trust and probate issues. And let me tell you, he's very, very busy. And when he's not mediating trust and probate disputes, guess what Judge Reiser does to decompress? He's a marksman hunter in the world of Warcraft. So thank you, Judge Reiser, for being in my life. Together, we make great things happen, and let's get started. Today, we're going to be talking about the following. We'll first review the current court confirmation sales process. Then we'll discuss the issues with the real estate court confirmation sales process, the issues with the current bid and open court form on sale of real property, which is an LA County form. We'll provide a perspective from the bench, and then we'll discuss the proposal to resolve issues with the process in the forms. We'll discuss the goal of the proposal, and then we'll take a look at the four new forms that are being proposed that I developed: the intent to bid in open court, instructions to bid in open court, overbidder's term sheet, overbidder's contract. Those are 4 new forms. Then we'll discuss implementing new California state rules of the court. And then we'd love to hear your feedback and any questions you may have for us. So many years ago, when I first started handling probate real estate sales, one of the professional fiduciaries I got to know invited me to join her in court so I can observe and learn about what happens during a court confirmed sale. When I arrived at court, my first question was, which contract does the winning bidder sign? The answer I got was, huh? And so my confusion about the process began. And as I experienced more and more court confirmed sales, I realized that California court confirmed sales involving estates and trust need restructuring. There needs to be clear rules that all parties understand, and there needs to be forms that enable standardization. This will enable escrows to close as quickly and smoothly as possible. It'll also help judges to avoid having to reschedule hearings and delay progress with getting real estate sold. It'll help keep the buyer's feet to the fire and ensure there are no disputes during escrow. Let's discuss the current situation. Some attorneys and agents bring a copy of the accepted contract to court and have the overbidders reviewed in the hallway. There is no statute that states that the terms of the accepted offer subject to court confirmation transfers to the winning overbidder. Let me repeat, there is no statute that states that the terms of the accepted offer subject to court confirmation transfers to the winning overbidder. Why do we need to have the winning overbidder assume the prior terms? Maybe they're not the most favorable to the seller. Maybe there was only one offer at the time and it wasn't great, but allowed the seller to go under contract so that a hearing can be scheduled to confirm the sale. And at this point, when you have overbidders coming to court, you really have a captive audience. You have overbidders who are excited about the property. Why not define the most favorable terms for the seller? The overbidders don't know what the previous terms were anyways. Some attorneys and agents don't bring anything to court. Overbidders are not aware of the terms and conditions they're agreeing to. It's not discussed by anyone in court. The only terms discussed are the purchase price, as is, no contingencies, 10% deposit. This leads to issues during escrow and disputes between buyer and seller as to who will pay the various transactional fees, and can lead to liability and losses to the seller, as there are no seller protections. All you have is the bid in open court form. And as you know, that's a very simple form that does not allow any space for detailed conditions and terms. And some attorneys, they add terms and conditions to the order confirming sale of real property that were not agreed to and which were not disclosed to the winning overbidder prior to bidding. Again, this can lead to dispute between buyer and seller once escrow opens. And it discourages buyers from participating in a real estate sale that requires court confirmations, since there's no transparency. So what you're getting is a lot of investors, savvy buyers, and the rest of the population, they're too intimidated because it's not clear, what's happening in court. What are they agreeing to? It's not a transparent process currently. Let's talk about what needs to be addressed. Here are some questions that I'd like to pose. Should the overbidders know the terms and condition of the sale prior to bidding? Should the overbidders sign off that they've reviewed the disclosures prior to bidding? Should the overbidders sign off that they've completed their inspections? And if they have not, they will conduct them after the court hearing for informational purposes only and hold seller harmless? What's the right way to handle the difference in 10% between the final court confirmed purchase price and the minimum overbid amount? Everybody handles it differently. There's no rule about it. Some have the difference delivered to them by the end of business that day or the next business day, either with personal or business check or a cashier's check. The court rules are all over the board. In Hebrew, we call this a balagan, which means chaos. Bidders come to court and are unprepared. Bidders don't understand that the terms in the court order that will be issued cannot be changed and will be adhered to by escrow. Bidders don't understand that once they provide their buyer's name and vesting information, this information can't be changed in escrow. This information goes on a court order to which escrow has to adhere. Bidders are not aware of the vesting options. And so they're standing then in a court and the judge says, how would you like to take title? And they have no clue because the buyer's agent didn't know they'll need to provide it. And if they did, they don't have the worksheet and they just don't know. Bidders' agents come to court and don't know what to do to prepare for successful overbid for their client. The buyer's agents have not prepared their client, the overbidder, to determine their max bidding amount, and therefore don't come to court prepared with multiple cashier's check and small increments or personal or business check to write that final 10% deposit that is the difference between the confirmed price and the minimum overbid price. The buyer's agent doesn't prepare their client to determine their desired vesting and explain that this cannot be changed later during escrow, since it's included in a court order. The buyer's agent doesn't prepare their clients to bring documentation such as government ID or organizing docs to ensure the spelling of the client's name is accurate on the court order, which can't, again, be changed during escrow. Now let's take a look at the issues with the real estate court confirmation sales process. Again, there's no standardization and there are no rules. This leads to errors, misunderstandings, and overbidders are discouraged from attending since they fear the unknown. Here's the current process. The overbidder arrives in court. The attorney or agent qualifies the overbidder. What does qualify mean? Do you check to make sure the overbidder has the 10% deposit, or do you also check for proof of funds and pre-approval letter? Nowhere is this definition provided, yet the judge asks every time, did you qualify the overbidder? Some attorneys and agents believe that the overbidder should assume all of the terms of the previously accepted offer subject to court confirmation. They stand in the hallway, they show the overbidders a purchase contract and counters and addendums, and they believe the overbidder understands what the final terms and conditions are. Some also show the disclosures. Some attorneys and agents don't show any purchase agreement nor disclosures to overbidders prior to overbidding in court. Then the judge calls the case to be heard. The judge indicates no contingencies, as is sale. He or she conducts the auction and then confirms the sale. The judge then asks the winning overbidder to spell his or her name and to specify vesting. He also asks for the commission amounts and the names of the agents representing the buyer and seller. In LA, the attorney or agent then completes the bid in open court form, that's an LA County form, indicating the buyer's name and vesting and commission amounts. There's not much space to indicate much else. So some attorneys attach the purchase agreement of the previously accepted offer that's subject to court confirmation. Others attorneys don't attach anything. But most feel like they need to attach something, but because really that form is so simple and there are so many terms and conditions in a purchase transaction, they think it's best to just attach something to protect the seller's interests. There's no detailed contract with all the terms and conditions. Therefore, most of the probate attorneys attach the contract or also to the order to protect their clients. However, these items were not agreed to by the winning overbidder, and sometimes the previously accepted offer doesn't contain the most favorable terms. Again, there's no statute stating this is what should be done, nor is there a local LA court rule indicating this. Then the certified order arrives and escrow prepares escrow instructions and settlement statements based on this order, and the buyer objects to paying fees that buyer never agreed to. We have a balagan, chaos. Let's discuss now the issues with the current bid in open court form, which is an LA County form. It states, it is understood that this bid is subject to court confirmation of the court. However, this form is completed after the judge has confirmed the sale, so that doesn't make sense. Where commission is discussed, it states if confirmed by the court to the bidder. However, it has already been confirmed. The bidder's signature fields don't allow for buyers acting in a representative capacity, such as LLCs, which happens very frequently, I'm sure you all know. There's no space to specify who the authorized signer is and to print that name. It doesn't provide for receipt of deposit payment made by buyer to seller. And, when you show up in court and you're asking the buyer to give the cashier's checks for significant amount of money, 10%, they want a receipt, and the buyer can claim that they deposited more than they actually did, and the seller can claim that they never received the deposit or didn't receive that much. That can lead to a dispute. And also there's no sufficient space to specify names of real estate brokerage agents and the respective commission amounts. Judge Reiser has spent many, many hours reviewing all of the local court rules for all 58 counties in California. Judge, please share with us your findings.
Well, okay, let's talk about the status quo, right? The probate code has rules on probate sales and confirmation hearings in the Superior Court. And those rules they're vague and they're not very definitive, right? The court has to find that whatever purchase contract is agreed to needs to find there's necessity and advantage to the estate, and the purchase has to be by a responsible person. And there's specific rules about calculating the maximum overbid price, and there are specific rules with respect to revamping the bonding if new money is coming into an estate. But by and large, it's very loose and it's generic throughout California. There are several rules of court as well. The probate code section is 10.300 at SEC. The CRC sections are 7.451 at SEC. But the rules of court are also just a few general notations about not commission percentages, but how a court needs to hold the commission findings in abeyance until the confirmation. So in orientation, for all the years, more than a decade that I taught judges probate, the training basically consisted of three things, right? What we taught was, here's what the minimum overbid is, and here's how to calculate it. How to conduct an auction, because that's kind of that's a bit unusual in terms of how a judge conducts herself or himself, and that unless the original the agreement proposed for confirmation and the overbid, any auction attempt is all cash, then you kind of leave it to the broker and or the personal representative, the executor or administrator, and or conservator if it's a conservatorship context, or the settlors if it's a trust context, on whether to accept it, right? And the court says, okay, is this to the advantage of the estate, and have you qualified the in an overbid auction situation, have you qualified them? And if they say yeah or yes, you go, fine, give me the order. And so the order lays out, it has some blanks. You have to fill in the name of the of the brokers and how the commission split is divided and the contract price. And you sign it and it gets recorded. Now, there are a lot of counties where there's a different protocol. You actually have to submit the order. It goes to the examiner / research attorney queue and in any event, but an order gets signed, it gets recorded, and that defines the sale price. So because the statutory rules are so minimal, a lot of counties feel they need to fill in the gaps or create rules because it's pretty, using legal terminology, loosey-goosey, right? And so I spent a few hours this weekend reading over the local court rules in California. And of the 58 counties, 24 of them have specific rules on court confirmations and probate sales. And guess what? None of the 24 are alike. I mean, there's similarities, but all of those 24 counties that have local rules have different court rules than the other 23. And so some of them, Los Angeles County, for example, has one rule, 4.39 with 3 subparts. It's not very definitive. Some counties have pages and pages of court rules getting down to details like how many caravans are supposed to happen on a sale. There's differentiation among counties as to allowable commission amounts. 2 counties, Los Angeles and San Diego, says it on a improved asset, it's got to be 5% or less absent extraordinary circumstance. 1 county, San Mateo, says it's 5% commission, actually 6% on the first 200,000, 5% on the next 300,000. And of course, since you can't get a property in San Mateo County for less than $500,000, 2% or 3%, I'm sorry, 4% on everything above that. A lot of counties, more than 10, say, well, we'll use 6% as our benchmark high commission on improved property. Unimproved property, Los Angeles and some others say raw land should have a 10% maximum commission, but some counties will break it down into, price and reduced commissions. It's all over the board. It's variable. There are a lot of other variances as well, from county to county. In Ventura County, I had no rules, because as a judge, I like the flexibility of thinking about the circumstance and making the statutory findings, but that's not the best thing to do. A lot of judges like rules. There is no real way of defining, what a successful overbid would be, other than, handing it over to the personal representative. And if there is an overbidder, and there's no rules, there's no statewide rules on a minimum on a down payment, right? I know Los Angeles is 10%. That's not the statewide rule, and that is not necessarily the general rule over the 58 counties. So should there be a rule? Shouldn't there be a rule? What happens if someone does pay a good faith deposit? Is it liquidated damages? Isn't it liquidated damages? Should there be a presumption that if that overbid sale or auction sale falls through no poor elocution, through no part of the seller, should there be a presumption that deposit should default, especially if it's something as large as 10%? I don't know the answer to that, but we ought to consider that in order to make more consistent statewide practice when it really is a very helter-skelter process. The issues that I see going into this, who is going to bid? What's a good bid? For a judge, what is a good auction bidding increment? Should a down payment be compelled? If so, I know that there's a thought in Los Angeles that as bidding increments go up, you should bring in a whole bunch of checks to pay 10% of wherever the sale price lands. I think that's a very odd way to do it. I think maybe you just ought to have people walk in with checks for a percent of the minimum overbid. And so what if it's not 10 point, what if it winds up ultimately being 9.88%? What if a successful overbidder defaults? Should a successful bidder be required to sign a contract on the spot? Probably, right? Should a judge, before bids are taken, get a piece of paper of who's there in court with an intent to at least present a minimum overbid? Probably, because when I did these auctions, I'd say, does anybody want to interested in buying the real property at 413 Main Street for a minimum overbid price of whatever? And you just wait for people to stand up, right? And sometimes nobody would, and sometimes more than 5 people would. And so you can do it ad hoc from a jurisprudential perspective, but really it would be nice for the judge to know who's in on the game. And ultimately, right, you don't want to conduct a hearing, a confirmation hearing, and find out that people are not pre-qualified, that the sale's not going to go through. And the worst thing that can happen in court, as you probably know, is to have cans kicked down the road and hearings rescheduled. So there's all kinds of questions. The Judicial Council has advised that they're open to considering statewide rules on this. Orit has done the very difficult job of putting out some possible forms that might be utilized throughout the state. They're by no means a final product. This is our initial incursion into this. So what we're actually doing is asking for outreach to the bar to give us ideas, to make comment, to make this a better process, because judges are not really involved in the process other than basically doing an auctions, doing the calculation of minimum overbid, making sure that the appraisal was conducted within 1 year of the sale. I mean, those are very fundamental things, but the real action happens behind the scenes. And because it's not part of a judge's life per se, it hasn't been regulated, or procedures haven't been put in place which necessarily come up before a judge. And so this is an opportunity at a fundamental level to get involved in this if you wish, and figure out the best protocol. Orit.
Thank you, Judge. So what's the goal of the proposal to resolve the issues with the process in the forms? Number one, it's to make the court confirmation process transparent, so more buyers feel comfortable coming to court and overbidding. If we have more overbidders coming to court, then that'll drive up sales prices for the estates and trusts that you represent. It's a win-win situation for everybody. We want to make the court confirmation process less prone to confusion. Attorneys will feel more comfortable logging in online via Court Connect. And since COVID, we all know that's most attorneys do that while the agent is handling the overbidders in court. We want to make the lives of attorneys easier and minimize risk while they're at home or in their business office on Court Connect. The agent is not trained to do attorney work. So, some agents have no probate experience. The personal representative can be a family member of the decedent, and they insist that their friend or their cousin sell the property, but that cousin, they don't regularly come to court, and they've never done a probate sale. So by having these forms, this will allow that the agent does things properly. If there's a procedure, the agent has basically training materials on what needs to be done when they come to court. And we want to make sure we're keeping the buyer's feet to the fire. That's critical so that we have successful closings. It doesn't fall out. We don't end up back in court, et cetera, et cetera. That just wastes everybody's time and money to the estate or the trust. So the terms, we want to make sure that the terms of the sale is disclosed to all overbidders. And for that, I'm proposing an overbidder's term sheet. We want to make sure that disclosures were addressed. And again, that's in the overbidder's term sheet. We want to make sure that everything is explained prior to bidding in court. And for that, I've developed 3 new forms: an intent to overbid, instructions for bidding, and overbidder's term sheet. We want to make sure there's no more wiggling out of the transaction. Buyer stating, I didn't know about this term or that. And we want to keep the judges' hearings to a minimum. We want to provide judges with the information they seek in forms to prevent errors and make the process easier. So like Judge Reiser mentioned, we want the judge to have a form in front of him that says, here's overbidder 1, 2, and 3. So he knows what to expect, who they are, what their name is. And that'll help the judge track the overbidding, during the auction process, track who's bidding what, and less prone to errors. So let's take a look at the four new forms that I'm proposing. Again, like Judge Reiser said, these will all need to be reviewed by judicial council, the various bars, as well as the legislative body of CAR and AIR. But adopting statewide forms will allow for standardization across the counties. And you saw that the local court rules for the various counties, they're all over the board, they're all different. And there needs to be basic statewide forms and court rules to address, the basics of the process. All right, I'm going to share my screen. Okay, this is the first form, the intent to overbid in court. So this is I try to keep it as simple as possible. It's a one-page form. This is a brand new form, doesn't replace anything that's already in existence. The seller's representative can be the agent or the attorney completes the top portion, as you can see, provides they complete this top portion, and they provide it to the buyer's agent to complete this bottom portion and have the buyer review and sign the bottom. So first of all, it confirms the commission amount here. This is a form that will be handed to the judge by the seller's representative, so to the clerk of the court, and that clerk will then hand it to the judge, so he has it when he enters the courtroom in the morning or in the afternoon, whenever the hearing is scheduled for. And so the judge will have one of these for every single overbidder. So he knows what the commission's amount, he knows who the seller's agent is, the minimum overbid, and he knows that the seller's representative has qualified the buyer. Here it states that the buyer, has X amount of money in the form of a cashier's check to purchase the property, and it verifies that they have qualified the buyer by reviewing proof of funds and pre-approval letter if there's financing being obtained. And again, this is important because not everybody knows what the word qualified means. Does the judge mean just the deposit check, or is it also proof of funds? So this makes it clear for everybody. And this bottom portion discusses financing type. And a lot of times in court, the overbidders, the agent or the attorney, they don't ask what is the financing type, and they don't go into the details. It's good to have the overbidder specify what their financing type is, so it's clear to everybody. Includes the overbidder's name, and now this probate code 10160.5. This allows the seller's representative to identify whether the buyer's agent is related directly or indirectly to the purchaser of the property, because in that case, they don't get a commission paid to them. So
Orit, Ken Petrillis asked the question, should there be a line for the commission on the overbid? It's a really, well, Ken thinks of things, and he's a great lawyer. That's a great question, because should there be a commission on the overbid? Well, probably. The different counties actually can disagree on what the actual purchase price is. There are some counties that say, well, you really ought to take out the standard closing costs because it's not really a reflection of what the actual price is. I'm not sure that's an appropriate way to look at it, but there are counties that go in that direction. Yes, there should be a line. The law is, even the state law is that the parties they can suggest a commission to the court, but the court is the final arbiter of what the commission is. I don't think I've ever had a situation where I pushed back going, I'm going to approve this contract, but I'm going to change the commission. But yes, ultimately, because you can't, the difficulty, of course, is you can't predetermine what the overbid would be other than the minimum overbid. But I think, yes, obviously the person who intends to overbid, the original purchaser might not do that, but if the bidder intends to overbid, they ought to be obviously prepared to pay the commission on the overbid. The question becomes, if there's an auction after that, how do you then, tie them down? And I think Orit's idea of having a contract signed once the court says confirmed, I confirm the overbid amount by this bidder, I think that form ought to define that specifically. So the answer is yes, but maybe not on this form, maybe on the contract form.
Yes, and we do have that actually in the contract. That's a good point, Ken. We'll get to that. That's actually the last form we're going to be looking at. So again, the buyer's agent, the reason I put that I included this here is because, there's no real procedure for the seller's rep. And like I said, a lot of times it's the actual real estate agent. They show up in court. Are they going to think to ask each buyer's agent, hey, are you related to the buyer? And are they going to willingly disclose that? Most likely not. So this makes sure that nothing falls through the cracks. And we ask her, are you related to the buyer? Yes or no? And if so, how? So then the buyer signs here at the bottom of the form, stating that they understand that if they become the winning bidder and they fail to close due to buyer's non-performance, the buyer's deposit is forfeited, liquidated damages, and of course, subject to judicial discretion. And the sale has no contingency. So this is signed before they even overbid. So it's clear to them, what they're about to undertake. So this is the form so like I said, once this is completed, the seller's rep provides that to the clerk of the court to provide to the judge. The next bid would be the instructions to bid in open court. All right, so this is basically an instruction sheet because buyer's agents, like I said, some of them are not experienced and they don't know, what to tell their overbidder. Their broker doesn't know. It's not very common that you find agents that are regularly in the courtroom and understand the process and procedure that goes on. So really the seller's agent provides this document to the buyer's agent before the hearing, if possible. That's ideal. And a lot of times when I'm marketing a property, once we're under contract and I continue to market it, and I include the date of the hearing, the location of the hearing, and I get inquiries from agents saying, hey, my client wants to show up in court. How do I do this? Well, what you do is you provide them this instruction sheet. And if they don't contact you in advance, sometimes it happens, they just show up in court, you provide it to them upon their arrival. And this does not need to be returned, this form. It's just for them to read these instructions. And these are, basic but important instructions about how to conduct themselves, what's expected to bring the 10% deposit, how do you handle the difference between the final accepted price and the minimum overbid amount in terms of the 10% deposit, to provide your business card. Sometimes they show up without a card, and the seller's agent would provide that to the court staff and write the hearing number in the back. And also to complete the intent to bid in open court form, which you just looked at, and what to do with it. And also make sure that they have documentation showing accurate spelling, because that's really important. Otherwise, you need to file an ex parte notice, as you know, and get things corrected on the final certified court order. And we have here some overbidders instructions. So this is for the overbidder to be prepared and not cause any delays. Let's see what's important here. I actually included like a vesting worksheet here for the overbidder. They can designate how they want to take title, so that they're prepared to answer that question when the judge asks them, should they be the winning overbidder? Let's see, we have some details here. So that's the instructions to bid in open court. And the next form is the overbidder's term sheet. And this one is, in a regular auction, not a probate, sometimes there are auctions out there. The way it's done is that the terms of the sale are presented to all the overbidders before they overbid. It's a basic auction practice. And so this is what I'm proposing to implement here. And again, this is a draft, which will go through lots of reviews and feedback. So this term sheet is to be completed by the seller's representative, either the agent or the attorney. And the seller's representative provides it to the buyer's representative, the buyer's agent, either before the court hearing, which is ideal, so they can review it with their client, or upon their arrival to court. And the buyer's agent reviews it in their entirety. They sign, they date it. The buyer initials the bottom of every page as well. So what do we have here? Let's take a look. We calculate the minimum overbid amount. Again, this top portion would be completed by someone like me, real estate broker, or the probate attorney, whoever wants to take care of that. It discusses here if the purchase price confirmed is greater than the minimum overbid amount, then they'll need to deliver in the form of either a cashier's check or personal or business check, the difference in 10% deposit between the final court confirmed price and the minimum overbid amount to the seller's attorney once the sale has been confirmed by the judge. So we have those instructions here. Who to make the cashier's check to, there are no contingencies, et cetera, et cetera. And I included here some per diem charge, an option to charge a per diem charge. And this has been very useful to motivate buyers to close on time. Sure, we run into some issues sometimes in escrow that cause some delays, but if you do put a per diem fee for the buyer, they're more motivated to actually close, and they'll do their really best effort to close. Otherwise, it's going to cost them daily. And here's the table. I try to make it as simple as possible. Of all of the closing costs, you can specify who's paying for what. When things are not applicable, you specify as such. Retrofitting, there's the misunderstanding in the industry that if it's a probate, you don't need to do anything and it's being waived. That's not true. Even though it's a probate, you need to follow state and local laws for retrofitting, the smoke detectors, the carbon monoxide, the strapping of the water heater, et cetera, et cetera. So what I do on my transactions, I actually get that done in advance. And then, if I have an overbid and I have overbidders, hey, I'm going to mark off buyer to pay and I'll put how much the existing invoice totals. Why not have the buyer pay for it? All right, additional terms. So if there's anything that was not covered here that needs to be addressed, you can specify in additional terms. And this is the important part, conditions of sale. These are conditions. I try to keep it, as simple as possible. Again, as a sale, no warranties or guarantees, selection of vendors is all, seller selection, the per diem charges is explained, seller's documents and disclosures. Basically, we're stating that it's the overbidder's responsibility to request it. The seller's documents and disclosures, including the title report prior to bidding in open court. And it's indicating they've reviewed everything and they're satisfied. And if they haven't obtained it for review, they assume any risk related to reviewing such disclosures and documents. They hold seller and seller's agent harmless. Repairs, I had a situation where I had an FHA overbidder, first-time buyer, overbid an investor in court. It was an FHA transaction. Well, FHA has, very specific requirements. They have an FHA appraiser. The appraiser visits the property and they need to make sure the property is habitable. Well, this property in Watts was not habitable. So I knew we would have some repairs coming. It was missing some doors on the kitchen cabinets. There was peeling paint, which is a big red flag. And so I knew repairs are coming down the road. So what I do when I have that situation to protect the seller, I indicate buyer to pay for any lender required repairs. And I make sure that they are lender required by communicating directly with the lender. So it is to be paid by the buyer using seller approved vendors. So you want to make sure that those vendors are fully licensed and insured so that you don't have, claims, if cousin is painting and he falls off the ladder, we have a problem now. So I do allow those repairs to be paid by the buyer, and I make sure that the vendor is licensed and insured, they review the bid, et cetera. Investigation and inspection of the property. Again, it's the overbidder's responsibility to arrange for an inspection, and we want them to do all of that before they come to court. And here they state that they assume any risks related to conducting investigation. They hold seller and seller's agent harmless of any liability, et cetera. Items including the sale. Let's see what else. This discusses a retrofitting, what it is exactly, number 9. Personal property and trash. I like this one. A lot of times, in these probates, there might be some extra trash. And so, this is favorable to the seller. I say that all personal property and trash that remains inside and outside the property after close of escrow shall be deemed abandoned. And the overbidder agrees to incur the costs needed to clear the property. So we don't have, additional costs later. Of course, I like to make sure all properties are clean and presentable, but if something should occur and there's something going on, they can deem it abandoned. This discusses what happens if the property is occupied, keys, remotes, and passwords, etc. So these are a lot of seller protections that I came up with that benefits the seller, and other conditions are here, free-form field, and again, buyer and buyer's agent sign this. And again, this is before the overbid, so there are no excuses on, I didn't know this is the term. I didn't know, during escrow, I didn't agree to this. It was never discussed by the judge. It was never presented to me. Now we know they signed off and it's been presented to them. No excuses.
I've received a couple of sidebar comments from one or more of the judges in attendance this afternoon. And they're very salient. So one says, I would add that instructions provide a section for title being taken by an LLC, because as we know, quite often we have investment groups and husband and wife, those other blanks, you ought to expand those to include entities in various permutations.
Yes.
Also, a judge commented, and this happened not infrequently, that when there's spelling changes, you have to go back to court to get another minute order through some ex parte procedure. So it's highly critical that that accuracy be a goal in the initial instance. There was another comment, and again, this is purely this is an important comment, and that is the term sheet, which we haven't gotten to yet, the contract, or actually the term sheet needs to disclose whether the real property is occupied or not, because if it's occupied and is subject to a lease, that is a pretty critical piece of information to a buyer, for all of the obvious reasons. You people don't necessarily want to buy a UD situation, and given the varying rules with respect to rent controls and elsewhere, throwing somebody out can obviously destroy a deal. So and it's not just, anybody who has ideas of things that ought to be considered should contact Orit, because what she's going to do is she's going to review all of the various local court rules around the state, attempt to select the best of the best, take comments from lawyers and brokers, and thankfully now judges and other interested parties to modify these forms in a way that the best possible presentation can be made to Corby Sturgis, who runs the court rules division of the Judicial Council, so that if and when these the rules of court are amended to include these additional forms, they don't have to have further immediate revisions.
Thank you, Judge. So those are great comments from the judges. I wanted to just address them really quickly. So I actually did include here, you can see on the screen, if entity buyer printed name of legally authorized signer and their title. So with an LLC, you can have a manager, etc. The authorized signer would sign their name, print their name, indicate the name of, print the name of buyer. That would be the name of the LLC. If it's an entity buyer, the name of the legally authorized signer. So if I'm the manager of the LLC, I would print my name, Orit Gadish here, and title manager. So that's actually addressed the entity situation, whether it's an LLC or it's a trust purchasing or any other type of entity. The spelling changes are critical. I agree. And the ex parte, this is the reason I created the instructions to bid in open court, to communicate that to the overbidders, because I know they're, when I show up in court, they don't know about that. Nobody told them. So that's in the instructions to bid in open court. And the occupied property, that's a great point. And I actually included it here on top. Let's see, occupied property, yes or no, that is critical. And I also included a condition related to occupied properties, which if property is occupied.
So food for thought related to that, yeah. Or do you think if there is an existing lease that there just ought to be perhaps an identification of, there's a 3-year lease with or a 5-year lease with 2 5-year options that's there.
Specify the details of the lease.
And that the main term expires X, or the option 2 expires Y, or whatever the
Exactly.
situation.
Yeah. It's critical to know. Yes. And I actually state here, overbidder understands that seller will only be providing rental/lease agreements, amount of security deposit. Yeah, they need to know all the details. And perhaps we add a checkbox that if yes, please provide, this to alert them to provide all that detail. So I'm going to add that to the form. That's an excellent point. So I'll put a little checkbox reminding the seller's representative to provide a copy of the lease and any other, the details they need to know. All right, this is great. So let's take a look at the last form. It's the overbidder's contract. So let me back up a second. So we're looking at the overbidder's term sheet. The buyer has reviewed it. The buyer's agent have reviewed it. They understand the terms of the sale. Everybody signs off. Now the judge has arrived. He's calling, the case, and the judge conducts his auction. He has the intent to overbid form, so he knows who the overbidders are. He doesn't, need to. He can take notes on the forms and track the numbers, because sometimes it gets very detailed, and when there's a lot of overbidders, it can get confusing who bid what. So you can use those forms to track. He confirms the sale. Now, as usual, everybody goes outside, the winning overbidder, the seller's representative, whether it's an agent or an attorney, and this is the overbidder's contract. Now, the seller's representative completes it, whether it's agent or attorney. And this, again, I tried to keep this simple because we already have the term sheet. So we confirmed the financing type, the winning overbidder's names, the title, which by now everybody knows what it is because they've gone through all these worksheets. Compensation of the final purchase purchase price. And here, this is really the deposit that's been missing. The seller's representative signs off here saying, I've received, X amount of money in the form of a cashier's check, and it can be and a personal business check, because remember, if they only bring a cashier's check for the minimum overbid amount, and now we overbid. So the easiest thing really is for the overbidder to bring a personal business check, because sometimes they don't know where it's going to end up, and they can just write, the amount in that check as deposit to purchase the reference property. Or you may have a case where they did not bring the extra checks, but they only have the 10% of the minimum overbid. So now they owe some additional funds to make up the total percent of the winning overbid amount. And so then the seller's rep would check off here, there are additional funds, and they specify how much that make up total of 10% of the winning overbid amount, which the buyer will deliver to the seller's attorney's office. In the form, it gives you an option as a seller's rep to decide how you want it done. Either it's personal business check, or if you insist on a cashier's check, you can do that. And you can specify when you want those additional funds. You can, will be delivered within 1 business day of the court hearing, or whatever you feel comfortable with. And the seller's rep here signs, and the buyer, the winning overbidder, completes this section, and they sign under the provision stating that they understand that this overbidder's contract and the overbidder's term sheet, which we just reviewed, that the overbidder has agreed to, and the resulting order confirming the sale constitutes the entire contract between the seller and overbidder. So there's no backing out. I didn't know, this is the contract.
Or maybe exactitude as to an overbid. I mean, an auction amount is necessary, and 10% of the minimum overbid amount just ought to suffice without having to, have further requirements. I don't know the answer to that, because it's really a practical question. And speaking of practical questions, David Silverstein asked one: are the buyer's repair fees paid to the contractor, paid through escrow?
That is, well, it all just depends. Sometimes yes, sometimes the buyers pay the vendor directly, and the vendor confirms their payment, so there are no issues, but it's an agreement between really the buyer and the vendor. But you can do it either way.
Okay, so there's 5 more minutes for questions and answers. And again, this is a initiation of a proposal to define, to further define how to conduct probate sales in California, not just in either side, the sales side of it, in its initiation, or the confirmation side on the jurisprudential side of it. So either through Q&A today or direct communication with Orit, you know, let's try to, you know, create a process that is, you know, vibrant and causes some traction so that we can get statewide buy-in for really good processing of these, and that the judges will appreciate it, because a seamless transaction is the best kind of thing, because then there's only one hearing and you never have to see at least the transaction again.
Yes, and also we can take a look, you know, once we finalize these 4 forms, we can take a look at those forms and come up with statewide rules of court based on those forms too. You can define rules based on those forms, and that'll create standardization across the board. So when you're representing clients across counties, you know, you don't need to worry about, you know, so many variances. And just, you know, the goal is to make everybody's job easier, to protect the brokers, to ensure that the buyer's feet are kept to the fire.
And Orit, can you tell everybody what your email address is? Because I know that Judge Luna wants to send you some more suggestions.
Oh, that would be wonderful. Yes, that'd be great. So my email is Orit, O-R-I-T. I'm going to actually put in the chat box, O-R-I-T at Geffen. So it's G like George, E, F like Frank, E-N, realestate.com. I'm putting that in the chat box. Again, you know, like Judge Reiser indicated, I would love to get feedback. My goal was to, you know, perfect these forms, make it as useful as possible for everyone. And this is a group effort, and I appreciate everybody's involvement and participation.